Okay, good morning and welcome to Construction Question Time with Brandon Silver. Good morning, Brandon.
Morning, Julie.
And today you're going to be answering another one of those frequently asked questions from the construction sector. So today we'd like the answer, please, to what is the obligation of pre-action disclosure in relation to the litigation process?
Yeah, so the majority of the vlogs that I've dealt with has actually been dealing with adjudication. And today we're going to be talking about litigation, which is another process of settling disputes. And what litigation is it's the process of settling disputes in a court of law. And this contrasts with the adjudication process, where if you have a dispute, you can refer it to adjudication and an adjudicator will determine the dispute. Adjudication is a much quicker process than litigation, and also adjudication can be considered as a cheaper option. Now, obviously that's a very brief introduction to what litigation is. Today, what we're talking about is the disclosure process in litigation. Now, what disclosure is, it's the stage where the parties disclose documents that are relevant to the issues and disputes to the other party. And the disclosure obligation is very wide. So you have to disclose documents that are both you rely on in your case, but also documents that are adverse to your case. So that's very wide-ranging disclosure obligations. Now, it tends to be the case that disclosure comes after the statements of case have been issued. Now, what the statements of case are, this would be the particulars of claim, it would be the defence and any counterclaim. So these would be the documents that the parties would be submitting. Now, this contrasts to adjudication, where, as I mentioned previously, you have the referral, the response, the reply, and so on. So these are the equivalent of that in adjudication. Now, what I'm going to be talking about today is disclosure that actually happens before any action has been commenced, so before any letter of claim has been issued. And this is an important issue because it does come up where parties seek disclosure of documents from other parties before any action has been commenced. So with regards to this, if a party requests documents from another party and that party does not comply with that request for documents, then the party requesting the documents can bring an application to the court seeking an order for pre-action disclosure. So that's what it's called, disclosure before any action has been commenced. And that's under Civil Procedure Rule 31.16. That is the guide as to this rule. Now, what the test is that the court will look for if this application has been made is that the applicant will only be successful if it can show it has a prima facie case. Now, that means that on the face of it, the party has provided sufficient evidence to justify a verdict in its favour in relation to its claim. Now, the best way of explaining this is by virtue of a case. Now, the case is Neal versus Barclays Bank. Now, the applicant in this case applied to the bank for pre-action disclosure and wanted the agreement between the bank and the applicant. The reason they wanted this is because they wanted it to help its case that there was a declaration that the agreement was unenforceable. Now, the judge held when it went to the court that the application was dismissed by the court, and the reason being that the applicant had failed to even begin to demonstrate that his agreement with the bank was unenforceable. So what this shows is that you need to have a prima facie case. You need to show some evidence to support your case before you can start asking for documents, which is in this case, the agreement, which they were then going to rely on to be unenforceable. This also shows another very important point, which is to make sure you have documents. A lot of the time, the reason parties are asking for documents is simply because they've lost them, and then therefore trying to find things that they can't potentially have. Now, this leads to the next point, which is that a lot of the time when parties are asking for disclosure of documents, it's really a fishing expedition. Now, what that means is it's a search or investigation undertaken with the hope, but not the stated purpose, of discovering certain information which will help their unparticularized case. So they're looking for documents. They don't know really what they're looking for. They're trying to hope that they'll find something that will be beneficial for the case, but they don't know exactly what. And in that case, the other party should be very wary and not necessarily just produce the documents for them. Some final things to bear in mind then if you are making an application to the court. Number one, the court retains discretion as to whether or not to order disclosure of specific documents. Now, what that means is that even if you satisfy the test and you have a prima facie case, the court could say, you know what, we're not going to order disclosure in any event. And that's why I mentioned before with CPR 31.16, it's the court may. It has a discretion, but it's not obligated to if it determines that the test is there. Number two, an applicant is less likely to be successful of getting an order for pre-action disclosure if the request is for a large number of documents. So if it's a very vague request for loads of documents, then that's very onerous disclosure obligations, and the court is very unlikely to order that. Also, it depends on the type of documents that you're requesting. If you're requesting documents that aren't deemed to be key to the dispute, which you've obviously put forward being your prima facie case, then again, the disclosure obligation is seen to be onerous and the court is unlikely to order pre-action disclosure. Finally, obviously, given that I've mentioned that it is sometimes very difficult to prove your case and for an applicant to be successful, if the applicant isn't successful, they're likely to face a cost bill ordered by the court. So if you're the applicant, it's very important that you put forward your case, that you haven't requested a large number of documents and that the documents are key to the dispute. If you're, however, on the other side, you need to make sure that they've proved these points. And if not, then obviously you should refuse it because it's most likely to be a fishing expedition. So that's pre-action disclosure and also a very brief introduction into litigation. Thank you for listening.
Thank you, Brandon, for clarifying that for us. And we look forward to another construction question time with you soon. Thanks,
Thank you, Julie.